right. Then I'm going to reintroduce myself for those of us who are joining us now. And this video will be available to anybody to watch, whether you were able to join us tonight or unable to join us tonight. So I am Nancy Friedman, proud to be president of the Houston chapter of Americans United for Separation of Church and State. For those of you who aren't familiar with Americans United, it's a nonpartisan, nonprofit education and advocacy organization dedicated to advancing the separation of church and state, of religion and government, as the only way to ensure freedom of religion, including the right to believe or not believe for all. We at AU use advocacy, education, the legal system, and faith outreach to ensure that religion does not dictate public policy, that the government does not tell Americans what to believe or how to practice their faith, and that discrimination is not justified under the guise of religion.
We're very glad to welcome you, Sarah. If you could introduce yourself and go ahead, and then you will be introducing Ken, our speaker for the evening.
Thank you so much for having me this evening. My name is Sarah Gillooly, and I'm the Vice President for Outreach and Engagement at Americans United for Separation of Church and State. I'm based here in DC, as is my colleague Ken, who you'll meet this evening, although currently we are all working from home. From those of you who joined the banter a little early, you heard us saying that given the density and the way that we travel in DC on the metro train, we'll probably be home for a little while longer. I was so looking forward to being with you this evening. I'm a Southerner. I grew up in Florida and Georgia and North Carolina. While I know Texans might debate whether they're Southern or just Texan, I feel a special affinity for the work that you all are doing every day in a state that is so critically important to the future of this country, to the courts, to democracy. So thank you, and I wish I could be with you in person. Mostly what I want to do this evening is introduce you to my brilliant colleague, Ken Upton. Ken is the Senior Litigation Counsel at Americans United, and we are so lucky to have his level of expertise, and we're also very lucky to have a Texan at Americans United. Prior to joining AU as our Senior Litigation Counsel, Ken was at Lambda Legal for 13 years, lived in Texas. We actually lured him to DC when he came to join our team. And when he was at Lambda Legal, Ken was litigating on issues of LGBTQ equality, non-discrimination in the workplace, the rights of same-sex couples who are parents, as well as some extensive professional background in HIV/AIDS, discrimination, and criminalization. So we have been really lucky to add that expertise at AU, especially as more and more often under the Trump administration, what we find ourselves fighting in the courts is the use of religion to discriminate in public policy and in public services and through taxpayer funding, which is some of the cases Ken will talk to you about this evening. Ken's an Oklahoma native, an Oklahoman by birth, but lived in Texas for many years. And one of my favorite parts about Ken's biography and getting to know him is he was actually the executive director of a 4,000 person church in Dallas, Texas. So I hope he'll tell us a little bit more about that. Both Ken and I are really delighted to be able to share the work that's going on around the country and the work that's happening right there in Texas. People are the lifeblood of Americans United for Separation of Church and State. Whether it is people like Nancy and Al and the board members who are elected this evening who are monitoring what's happening in their local communities, educating voters and citizens and members of our community about these issues, or it's the many thousands of people who come to AU each year filing legal complaints, or our clients. We have an amazing client right now, a woman you'll hear more about named Amy Madonna, who is a foster mother in South Carolina, who was turned away from a publicly funded foster care agency because she's Catholic, and the agency said only evangelicals need to apply here. So we're so grateful for our volunteers, our clients, as well as those who provide the financial support to make sure that AU can remain the premier protector of separation of religion and government in this country. So without further ado, I want to turn it over to my colleague Ken, and I'll look forward to joining you during the Q&A.
Thank you, everyone. And I'll join my thanks for getting to talk to you tonight and to be a part of this great organization and your local chapter. I'm going to talk basically in 3 pieces tonight, and between each one we'll have a time for questions and answers. The common thread that's going to run through all of these is the importance of the United States Supreme Court. I work with the litigation department. I am senior litigation counsel. And so what you're going to hear from me tonight is about lawsuits and the courts. But that's just a small piece of what Americans United does. And so I hope if you're interested in some of the other aspects of our work, you can go to our website and look. We have a robust public policy group that works with the Congress and works with state legislatures. We have a communications group that helps fashion the messaging. And then Sarah's team is very active in trying to develop our outreach in the community. So my piece is just a small piece of it, but I like to think it's an important contributor to the work we do. And I'm going to divide it into 3 pieces tonight. I'm first going to talk about cases that are currently in front of the United States Supreme Court. These are cases that will have a dramatic impact on where our future will go, because when it comes right down to it, the law that we protect, we ensure that there's a proper application and interpretation of the Constitution as it applies to religion, and as to the various state constitutions and other federal laws and state laws that protect free exercise. And so the ultimate authority for the courts is the United States Supreme Court. And these are the cases right now that are pending before the court. We expect to have decisions in them by the end of the month or at the earliest, the beginning of July, and they will set the tone for where we go forward. The second piece I'm going to talk about is generally some cases that we have in the works to give you a flavor of some of the things we're doing in the courts. And in this area, you're also going to see that there is a component where the Supreme Court will have a significant effect, and in a case that is currently set to be heard this fall before the United States Supreme Court. And then the last piece I think that's interesting to listen to is a lot of litigation that has sprung up just in the last 2 months around the different state responses to the COVID-19 pandemic, which has caused a lot of conflict between people who feel like their religious freedoms are being impinged and state governors and other officials who are trying hard to protect the public health. This is not a new issue, but it's one we haven't seen for a while, and it has reared its head in a way that it's caused a lot of activity in the last couple of months. And again, the key here will be a recent Supreme Court decision that affects it. So that's the theme for all of these, is watch the Supreme Court. So let's start about the cases that are pending. There are 4 sets of cases I want to introduce you to. The first 2 have to do with discrimination in the workplace. One of them is a trio of cases under the 1964 Civil Rights Act that prohibits discrimination on a wide variety of bases, but the one that's at issue right now before the court is discrimination because of sex. 2 of the cases, Altitude Express versus Zarda and Bostic versus Clayton County, Georgia, are cases that involve whether there is protection under the federal non-discrimination laws for discrimination in the workplace against people because of their sexual orientation. Basically, does sex discrimination being forbidden protect gay and lesbian people? The other case that's a part of this trio of cases is RG and GR Harris Funeral Homes versus Amy Stevens and the EEOC. This is a case similar to the first 2, except the issue here is, does sex discrimination protect transgender individuals based on their gender identity? Now, I grouped these three cases in my talk this evening because along with the case I'm going to talk about next, these are cases that all talk about discrimination in the workplace. And although the ones I just mentioned aren't directly involved with religion, they ultimately will have an effect on how religion plays a role. And let me say this is why. In the transgender discrimination case involving Harris Funeral Homes, Amy Stevens is a transgender woman, and she was fired on that basis. One of the reasons that the funeral home gave for firing her was that it violated their deeply held religious belief to hire a transgender person and to encourage their transition at the workplace. That issue is not before the United States Supreme Court. The people who brought that case on behalf of the funeral home have abandoned their religion claim, but only for the time being. It will resurface someday in another venue. But we have to acknowledge that behind all of these cases, there is frequently an underlying current that the discrimination is motivated by a sincerely held, deeply held religious belief about the role that someone's religion plays in how they view gay and lesbian people or transgender people. So this case will not resolve the religion issue, whether religion can justify discrimination, but it's the next step, because if these people who are bringing these claims are protected under Title VII of the Civil Rights Act, then as a matter of federal law, at some point we'll have to decide whether religious motivation still is an exception to protecting LGBT people. The other case is a religious discrimination case, or I should say a religious exception case. There are two cases involving Catholic schools in California. One is called Our Lady of Guadalupe versus Morrissey Beru. The other is St. James School versus Beale. And in each of these cases, the United States Supreme Court is trying to decide if a doctrine known as the ministerial exception allows these schools to discriminate, and in these cases, terminate the two employees of the school because, in one case, because of age discrimination, and the other case it was because of claimed disability discrimination. To understand these cases, you have to go back a few years to a case the Supreme Court held some years ago called Hosanna Tabor. And that case involved whether the government can interfere with a religious organization's ability to hire people to be its ministers, its leaders, and to promote the proselytization of its teachings. And so the court in that case, which was fairly simple because it did involve a clergy person, said, well, that the United States Constitution doesn't permit us to get involved in ecclesiastical matters, and the government has no interest in enforcing these non-discrimination protections in the context of a church or a religiously affiliated organization that is simply advancing its mission. That was a pretty easy call then. Now the question is, if the school is a religious school and they have teachers, some of whom teach religious doctrine and some who just teach regular curricula, where is the dividing line for who constitutes a minister and who doesn't? And when it comes right down to it, this is the ultimate clash between respecting and staying separate from interfering with religious organizations' mission, including churches, and protecting an important government role of non-discrimination in the workplace on a number of grounds. And that's the issue here that's going to be decided. Where is the dividing line for determining when the government can interfere with the hiring decisions of a group that claims to be affiliated religiously? These two sets of cases is the first time in quite some time that the Supreme Court is going to delve into the employment sector and when religion gets to do what it wants to do, and when the government gets to protect people from religious institutions doing what they want to do. We'll watch those carefully to see where the dividing line is for the exception for ministers, and is it based on just their title? Is it based on their credentials, where their education was? Do they claim to be clergy? Or does it extend to teachers, even teachers who are grade school teachers that teach mainly secular doctrine? And then, of course, with respect to the gay and lesbian discrimination cases, we'll see where that leaves us when we have to address the religious excuse or justification for discrimination. Okay, that's the first two sets. There are two other sets that are before the court this term. One is another in the long line of Affordable Care Act, or as a lot of people call it, Obamacare cases, where we try to figure out where the line is for allowing an employer to withhold certain protections under their health insurance, mostly for contraception and women's reproductive health. But this could extend also to transgender protections for transgender health. There have been a number of cases. Some of you may remember years ago, there was a Hobby Lobby case where Hobby Lobby said, even though we're a for-profit company, we're closely held, we have a religious mission, all of our owners are deeply religious, and so we shouldn't have to provide health care, we should get an exemption. There have been a couple of cases since then involving Wheaton College and a case a few years ago called Zubik, which tried to draw the line of what you had to do to claim an exemption. And now we're in the middle of a broad push out from the Trump administration to try to expand religious exemptions for reproductive health to not just specifically religious institutions, but anybody who has a conscious objection to providing the services and whether they're entitled to have an exception to the Affordable Care Act. The regulations that the Department of Health and Human Services have enacted just unbelievably expands the conscience exemption, not just on religion basis, but across the board on all kinds of conscience objections. And that is aimed primarily at the contraceptive coverage mandate. We'll see where the court goes with this. The court's been pretty inclined to keep expanding the exemptions and cut back on what the Affordable Care Act has to require. And in this regard, I'll also say that we actually have a case that's pending in Indiana involving a group called Irish for Reproductive Health versus Health and Human Services, where the University of Notre Dame tried to do away with the same types of insurance coverage for contraception based on a backroom deal they cut with the government that is now being reviewed by the court. Finally, the fourth area in the Supreme Court cases is a case called Espinoza versus the Montana Department of Revenue. This case involves programs that actually are effective in a lot of states where either the Constitution or other laws of the state forbid providing revenue to religious schools. Sometimes these are called no aid laws, or they've also been called based on an old amendment called the Blaine Amendments. Texas actually has two of these laws in its constitution. And so there is the possibility that they could have something to say about Texas's law. But the bottom line is the question of whether if the government provides religiously neutral student aid program funds to people to use in secular schools and private schools, if it avoids them, if it entitles them to that access, do you have to provide the same funding to students who want to go to a parochial or a religiously associated school? Montana has the law in its constitution saying funding can't go to religious schools. The government said, but you have to provide it to religious schools if you provide it to other secular schools. The Montana Supreme Court settled the issue by saying, fine, the program's not going to happen at all, just stop it, and then that takes care of it. The United States Supreme Court is looking at it now and saying, not so fast. If you've been giving it to secular schools, you may be required to give it to religious schools. So that's a long time coming, but there's been this constant erosion of protections to avoid funding for religious institutions, and we see the Supreme Court willing to take that on. So those are the four primary groups of cases that we'll get decisions in within probably the next month. And depending on where these go and what the Supreme Court does, and I will say that the Supreme Court has become increasingly conservative and willing to entertain accommodations for religious groups, some ways troubling because it's accommodations that sometimes harm other people, but we will see what the Supreme Court does and where it leads us. And on that, Keith, I think I'll let you tell me if we have any questions.
We have a question. In the interest of time, I think I will limit this to a single question, but we'll see how much time we have. This question has to do with your elaborating the response to the claim that all of the teachers and that all of the teachers are part of the religious mission of the school, as opposed to, say, the housekeeping staff. What is AU's response to that? Because the secular content is not the only part of what the role of those teachers are.
Well, that's exactly the issue that the Supreme Court's struggling with, is how do you draw that line? And it was interesting in the oral arguments before the court, they picked examples and asked each of the attorneys to provide their proposal for what the test is. So on the one end, you've got clergy people who are ordained or educated in the doctrine and all of that, whose mission in the organization includes not just instruction, but may also include leading worship, providing other types of clergy services. The opposite end of that, which came up at oral argument, was what do you do with the custodial staff, the janitors and the administrative people who really have very little contact with the students but run the organization? And it seemed that everyone agreed that clergy's covered, janitors aren't. But then when you got in between, there seemed to be a lot of gray area. So if someone, for example, teaches secular subjects, let's say they only teach history, and there may be a religion component, but from a historical standpoint, not a doctrinal standpoint, or they teach math, or they teach science. The fact that they may also accompany the people to a midday service, a worship service, doesn't in and of itself seem to indicate that they have a role as someone who imparts the doctrine or teaches the doctrine. On the other hand, you have a lot of people where it is hard to tell that their secular teaching is completely separate from their religious teaching. And that's what the court's struggling with. I mean, some of the suggestions were, do you look at how they were trained? Do you look at whether they hold themselves out to be a true minister, or do they hold themselves out to be a teacher? Do they really teach, or do they really just supervise people who will go to chapel for prayer service? Or maybe they lead a prayer that's not specifically pastoral in nature. Maybe it's more of a routine type prayer, like saying grace at dinner. I mean, if someone says grace at dinner, does that make them a pastor? Or does it just make them someone who always says grace at dinner? And so it is a difficult place for them to draw the line. We have taken the position with the court that there's not an easy answer. In fact, in the two cases that are before the court, I said one teacher was dismissed because she claimed it was because of disability. She had breast cancer and was out for treatment. The other teacher said it was because of her age, so it was age discrimination. And in looking at the facts, we suggested that those two might come out very differently, depending where the court draws the line, and based on what they actually teach, what their assignments were, what their background was. So it's a hard question, and there is no bright line rule now. And I'm not convinced from the oral arguments that the court has identified a bright line rule that's going to get all the votes yet.
Okay, thanks, Ken. I think that it would be, again, like I said, in the interest of time, if we go to the second segment of your presentation. We do see some more questions coming in, and we will hold those until the very end, and then see if we have some time for you to address those.
Great. Okay, so the next case, the next set of cases I want to highlight are actual cases, and I'm sorry if you can hear the siren behind me. I unfortunately live on a street where ambulances go by a lot, but I am going to talk about a few of the cases that Americans United has currently that are not, with the exception of one that's not before the Supreme Court, but we think are going to be very important cases for the coming year. A couple that I'm not going to actually talk about, but just mention so you get a flavor for the variety of the cases. The first one is a case that we just filed a brief in today called Mark Janney versus Gomez and others. It's a prisoner who was out on parole. The defendant is, among others, is the parole officer. And as terms of his parole, he was a homeless person, required to take up residence at a local mission that was approved by the parole board. And as part of his requirement for being released on parole, he had to actually participate in all of the religious aspects of the mission, which include teaching and church. And he wasn't a religious person, at least not in the sense that the homeless shelter was. He objected to doing that. He said he didn't want, he would be happy to live there and abide by the rules, but he didn't want to participate in the religious instruction. And so they revoked his parole and sent him back to prison. We filed a brief in that case saying that clearly is a violation of the Establishment Clause and his free exercise rights as well. Another case that's been taking up quite a bit of time is a couple of cases involving the current administration's rules around conscientious objection for health care. One of those is based in California, Santa Clara versus Health and Human Services. We represent a wide variety of plaintiffs who involve healthcare clinics, doctors, and other types of people who provide nonprofit services to public health. And then the other case is the City of Baltimore versus HHS, where we, along with the city, have filed a lawsuit for the same reasons, that the new rule that the Health and Human Services has enacted permits anybody who's in the healthcare industry, whether they be a volunteer, an employee, whether they be a doctor or a non-doctor, an administrator, insurance professional, anybody who has a conscientious objection to a service that the clinic performs for a patient has the right to object, and you can't reassign them and you can't take any action against them. There already are conscious objections that have been around for many decades about doctors and nurses and their ability to opt out of certain services, mostly abortion-related services. And those have worked fine for quite some time. But this is a much broader rule that would permit someone an objection if they're in the healthcare industry, or even a volunteer in the healthcare industry who objects to any service that they have a moral or religious objection to, including service for transgender people, which is a concern for many of these clinics, but also service for women's reproductive health, not just abortion, but other types of health, and others that we may not even know about. I mean, they could object to the plaintiff based on the plaintiff's identity. Maybe they don't like homeless people. Maybe they don't like young women who are pregnant, who are unmarried. There are lots of reasons that an objection could be held under this new rule. And so we, along with a number of other groups, have sued the Health and Human Services Department about that. And courts in 4 different states have enjoined and set aside that rule, and it's on appeal now. So that's a couple that I would just mention. The ones I actually want to talk about involve a Supreme Court case. We're back to the Supreme Court again. That is set for this fall, and it's called Fulton versus Philadelphia. And the premise of the case is this: healthcare is a concept where the government uses its authority as legal protector of citizens who are unable to protect themselves, here children, And when the government exercises authority, they can intervene in family affairs and they can place the children in government care for their own benefit. This is what is known in most states as foster care. And once the government does that, it has a particular responsibility to respect all of the constitutional limits in how it treats the child, both in its placement with people to care for it, and ultimately with the goal of returning it to its biological parents. Frequently what the governments do, Texas is one, but frequently what the governments do is they license private agencies because it's an overwhelming task and there's so many children in foster care. And these agencies basically act on the government's behalf to help care for these children, place them with appropriate foster parents until they can be reunited. And many of these private agencies are religiously affiliated. In the cases at issue that I want to talk about, one in Texas and one in South Carolina, the entities required the people who wanted to be foster parents to submit to their own religious doctrine. And if they wouldn't do that, they would not consider them to be foster parents. Amy Madonna is our client in South Carolina. Sarah mentioned her name. She's Catholic. Her family's Catholic. She grew up in a foster household as a child, had lots of foster siblings growing up, and has 3 children of her own, 2 of whom are special needs children, and really would like to foster people in South Carolina, especially special needs children. What happened was the only real agency who they could work with in their area was a company called Miracle Hill Ministry. And Miracle Hill is evangelical Protestant and will only work and place with evangelical Protestant people. So they turned Amy away as a potential foster parent, even told her she would be ideal, but they just don't work with Catholics because they only work with Christians. A little lost on them that Catholics are Christians, but you know, we'll let that go for a moment. So that's one. And the other one is a couple we represent out of Fort Worth who have tried to foster with the federal government under a program that brings in unaccompanied minors from out of the country. And because they're either unaccompanied by an adult or they're not with an adult for other reasons, then they are placed in foster care with the federal government and they are put in places. Ironically, the company that turned this couple away was Catholic. Catholic Charities of Fort Worth turned them away because they were a same-sex couple. They were married, but they were a same-sex couple, and they didn't mirror the Holy Family, and so they couldn't place them. In both cases, these are entities that are acting on behalf of the government, so the government could never do this, so the people they contract with shouldn't either, and they receive taxpayer funds to do it. These 2 cases are currently in the courts. The third case that I mentioned, the Supreme Court case of Fulton versus Philadelphia, is this very case out of the city of Philadelphia, where the Catholic related entity refused to place children in foster care with families who were same-sex couples. And so the city of Philadelphia did not renew their contract. They sued and said that you had to renew it because you can't discriminate against us on the basis of our religion, and that's what you're actually doing. That case is currently before the United States Supreme Court and will be argued in probably October. And so we may find out what the Supreme Court's position is on whether religious institutions can work on behalf of the government and insert their own religious criteria in providing government services. And that's all I'll say about the second piece.
Okay, thanks, Ken. We have one question that has to do with the right to refuse service in healthcare settings. Are these clinics publicly funded? And for clinics or practitioners who are not publicly funded, is there any difference in the legal status or the ability to have a right to refuse?
Well, so the answer to the question is yes. Most of the entities you sued are nonprofit entities. Some of them receive government funding, and some of them, well, all of them receive government funding, because the hook for the conscience clause is the government says if you take government funds, then you're required to at least provide accommodations for doctors and nurses who have objections. That's part of the string that's attached to the government funds. So the answer to the question is yes, all of these entities do, although that really doesn't say a lot, because the federal government provides the vast majority of funding for all hospitals, public and private, for most clinics, public and private. I mean, the amount of money that HHS controls is just unbelievably wide-reaching. And so while there might be some people who could forego government funding, a good example is the city of Baltimore has a very robust public health department. They said that they would all but have to shut down if they lost federal funding. Even though it's not all of their funding, it's a significant enough piece of it that it would cripple their ability to, and in their case, since there's a public health department for a government entity, they're responsible for responding to pandemics and other types of public health issues, not just public services for individuals. Most of the other clinics are large nonprofits. There were some private doctors who received Medicare and Medicaid funding. So it's just to say, does it involve government funding? It's very difficult to find anybody in the healthcare industry of any size that doesn't rely on government funding.
Here's another related question about the Amy Madonna case.
Mm-hmm.
So what made the Amy Madonna case a legal matter rather than one around which to lobby legislators, arouse public opinion, influence influencers, etc.? This is really a question about AU and its role. Can lobbying, etc., be done in parallel with the litigation efforts?
There is lobbying going on around the foster care programs, including some heavy lobbying in Texas with Ken Paxton and Governor Abbott and some of the people here. The problem is that most of the legislatures and most of the administrators who are in control of these cases are not receptive to changing it. So let's talk about in Amy's case what happened. Initially, when Miracle Hill, because these entities have to be licensed and they get their licenses renewed periodically and there's a review. And under the old governor of South Carolina, when their equivalent of the Department of Family Services went up to look at renewing Miracle Hill's license, they discovered they were discriminating, which is a violation of South Carolina law. Also a violation of federal law under the Obama administration, which said if you take federal funds, you cannot discriminate on a number of bases, including sexual orientation. Well, as soon as that went up, they were put on probation, basically a conditional approval to continue their license. And then there was a change in government at South Carolina. Nikki Haley left, and their current governor, whose name I just drew a blank on, took over, and they shut down the investigation. And the governor issued an executive order exempting them from those requirements. Then he lobbied the Trump administration, which had now taken over HHS, for an exemption from HHS, from their regulation. So yes, lobbying is a factor we try to go to because it's a longer term solution many times. But in this particular situation, both the state and the federal government had turned in a way that was not helpful. And of course, if anybody follows Congress right now, it's almost impossible to pass anything in Congress. But the truth is that once both administrations turned, then the court became the only justification, and that is the piece that's left for us until there are changes in administration, both at state and local and national level again. And in the meantime, we do have to use the courts.
Okay, thank you. I know we're all interested in the third segment of your talk, which has to do with COVID-19, public health, and the effects of the pandemic and the relationship between public health mandates, public health law, and the desire of churches to not have to abide by those. I'm signaling what I'm sure you're going to talk about. Go ahead.
Well, this is an area where we didn't think we'd ever be doing any litigation until a couple of months ago. But as everyone knows, in response to the pandemic and the COVID-19 cases that have sprung around, there's been a tension between the different approaches governors have had to try to, and local officials sometimes, to try to stop the spread of the virus and hopefully buy time to at least look for treatment options to keep the healthcare system from becoming overwhelmed, and ultimately to find a vaccine that would help us get back on track. In the couple of months since this all really took hold, I would say early March to now, there have been 60 cases in 25 states involving challenges to orders by governors or other officials, usually involving lockdowns or orders that certain large group gatherings not happen, or if they do happen, that they happen under certain restrictions. And a few of these have even happened in Texas. There have been 3 filed by a guy named Steve Holtze on behalf of himself and a couple of other people, represented by a guy from Houston named Jared Woodfill. They first sued in the Texas Supreme Court, challenging the Harris County rules about closings, and then that was dismissed voluntarily when there were some changes to the orders. There have been a couple of orders since then, one from Governor Abbott, which is fairly generous, and one from Harris County still, which is fairly restrictive. And there's now a case pending in Harris County District Court, as well as in Travis County District Court, which is in Austin, challenging both the governor's response and the Harris County District Judge's response, or Harris County Judge's response. So those cases are pending. AU has filed briefs in 17 of the 60 cases. The problem with these cases is they're all so different because of the facts. Each order is structured in a different way, and they're based on the governor or the local government officials' view based on science and health of what is going to be most effective in a particular setting. But generally speaking, some of the things that are at issue is, to what extent can the government limit public gatherings, especially large gatherings? To what extent can they allow public gatherings but provide restrictions on how you gather or where you gather, indoors versus outdoors? Do you have to do it remotely? Can you do it in person if you can provide social distancing or wear masks? What about touching? What about food? All kinds of issues that arise. And then, of course, they also run afoul sometimes of trying to designate certain types of activities essential and certain types non-essential. So, for example, going to a hospital might be essential, but going to a doctor's clinic may be non-essential, especially for voluntary type procedures. Or going to the grocery store may be essential, but going to a concert may be non-essential. And so most of these cases have sprung up around some aspect of the infringement that churches perceive on their ability to gather and worship as a violation of the First Amendment, freedom of religion, free exercise of religion, and the government's important role in addressing public health and taking action to stop the spread of disease. These cases have come to loggerheads a couple of times over this last century. I mean, in the early 1900s, there was an issue about whether the state could have forced people to have vaccines in certain instances. And there were other instances that did involve public health. Can we force people to keep their children in public school to a certain age, or is there really an important reason for doing that? So there are a handful of cases in which we have had to deal with the conflict between government trying to protect the citizens broadly and whether they can take action against certain religious exercises that could pose a risk of public health. So most of those cases, almost entirely all of them, have gone against the churches who challenged them. There are a few exceptions. There was a case in Kansas that was favorable for the church challenging the rule, and there were cases in what in geographic terms for the law constitutes the Sixth Circuit Federal Court. That includes states like Kentucky, Tennessee, right around that part of the country. And there were a handful of cases there where the churches were successful. But in each case, the cases are very fact specific. How did the government draw the lines, and could they have drawn them in a way that was less rigid or less targeted toward churches versus other people that have similar risk factors? That is the landscape until about a week ago, until one of the groups or two of the groups, one in Illinois and one in California, filed petitions with the United States Supreme Court to try to stop the local orders. In both cases, the Supreme Court rejected the challenge. The first one in the Illinois, they rejected because the governor just changed the order, and that's part of the problem with these cases is the response to the virus is a moving target because the governors are constantly adjusting. But the one in California, it was a 5-4 decision, and the Supreme Court, in a very closely divided court, denied the request to stop Governor Newsom's order that restricted the way churches could gather and worship. And the Chief Justice, John Roberts, for the Supreme Court, wrote an opinion in which he tried to explain his thinking in denying the relief. He said, you know, these orders are intended to stop an acute respiratory illness that has killed more than now 110,000 people. And there's no known cure, there's no effective treatment, there's no vaccine, and people may be infected before they ever have any symptoms, so they may be unwittingly infecting others. And so he said, in light of this, he said, we look at a couple of things. We look at whether the restrictions that are placed on churches are similar to or more severe than the ones placed on secular gatherings of similarities, like lectures, concerts, movie showings, spectator sports, theater performances, things where lots of people gathered in close proximity for an extended period of time. He said, then we also look at whether they exempt people or treat more leniently gatherings that are dissimilar. So, for example, they're giving exemptions to grocery stores, to banks, to laundromats. Are those similar or dissimilar? And he says those are dissimilar. They're people don't congregate in large groups. They don't remain in close proximity for extended periods of time. And so we have to look at apples and apples. We have to say, who is the church being grouped with? And if the church is not being treated worse than or more severely than secular counterparts who have similar risk factors, then the question is, who do we defer to? And there are cases going back to 1905 where the court says, in the case of a pandemic or something like a social health crisis, it is a dynamic and fact-intensive matter, and the response is subject to reasonable disagreement. And the Constitution entrusts the safety and health of the people to the states, not to the federal government. And when those officials undertake to act, they're dealing with medical and scientific uncertainties, and you give them extremely broad latitude. And unless they really, really exceed those broad limits, then an unelected federal judiciary doesn't get to second guess them. And so he allowed California's order to stay in place. And since that time, it's had a dramatic effect on the new bringing of new cases and the status of those that are existing. The two in Texas that I mentioned, that are one in Harris County and one in Travis County, they are both currently pending, and the court's just now taking up the request of the government to dismiss them. The one in Harris County was scheduled to be heard Friday, but it's been continued to the middle of the month. The one in Travis County hasn't been set yet, but we'll see if the action of the U.S. Supreme Court leaves the courts inclined to just dismiss those and let the government officials do what they think is best in light of best science. As far as the court's concerned, the remedy, if people are unhappy, is the political process. If you don't like it, vote out the people who made the bad decisions. That's all I'll say about those. We could talk about, there's some interesting stuff today. In fact, there was an article in the New York Times, there was another one in an online blog that had a bunch of public health people rank different group activities for how risky they were. And as you can imagine, even the health professionals don't all agree. But it's interesting to put where they put different types of things, everything from bars and music concerts and churches to going to the store, going to the dentist. It's really fascinating to see them try to rank the risk factor. And I don't think we're done with this yet, but I do think that we probably, as places start to reopen, we probably will see less litigation. It's just been an interesting wrinkle that no one expected.
Okay, Ken, we do have some questions. The first one I want to read, and then I want to add something to it myself. I'll just read this one as it came in. You refer to government limitations to control gatherings during the pandemic. But these limitations are usually the result of an executive order issued by the president or a governor. What allows the executive to issue these orders? Is there a statute, a constitutional provision? There's no legislation on this particular topic. What gives the executive branch the right to be able to issue these orders?
The answer to that is going to be different in every state. In fact, one of the cases we were involved in was in Kansas, where there was an issue about whether the Kansas legislature, or actually a committee of the Kansas legislature, or the governor had the authority to issue the executive order. But it's sometimes in the state's constitution. It's sometimes in the state statutes. It usually if it's in a statute, it usually is in a statute that authorizes the governor or some other executive on a broader range of national emergencies or state emergencies. So, for example, the ability to respond to hurricanes and tornadoes is probably one that is a part of a statute somewhere in Texas. I haven't done the looking, but I would be surprised if the governor didn't have the authority to call out the National Guard, to issue quarantines and restrictions on entering certain areas that are damaged. And generally, those are the types of statutes that would include public health. With respect to the federal government, the Constitution specifically provides that the states are entitled to maintain the health and safety of the public. So, that is a constitutional mandate that, so for example, there's no authority for President Trump to impose an order on the state of Texas to protect public health, absent something more. I mean, generally speaking, under the 10th Amendment to the Constitution, that is expressly reserved to the states. And so most states, it's the governor. It isn't always the governor. Sometimes it's set out in statute, and like it was in Kansas. And sometimes it's set out to in terms of what the local governors can do. So an example, in Texas, you might want to look to see what the law permits the county judges to do on a county by county basis. But maybe the county commissioners have some authority to legislate in that area too. Ultimately, within the state, the governor will trump the local government. So Governor Abbott would have the right to override and localized decisions by, usually not city, usually it's the county, but that's why you have county health departments. But that's the best answer I can give you as a generality.
Okay, thanks. Another question. Someone's been reading our good literature. The May issue of Church and State said that, or it's a question, would the worldwide pandemic undermine church-state separation? How do you think that might develop?
Well, I don't know that the pandemic would undermine it. I mean, I think there's a movement right now in the United States that, I mean, most of the protections that have been developed in, at least in the federal law, for religious freedom and religious exercise, particularly, have been geared toward protecting minority religions or people who choose not to have a religion, because those are the people who tend to experience the wrath of the majority. That's taken a turning point in the last decade, or maybe even longer. And what you find now is an empowered religious majority, which includes frequently Christian nationalists or other majoritarian religions who have seized the political power to create a favorable government for accommodation and preference. So what most challenges us today is the courts, especially the Supreme Court recently, and the government's attempts to weaponize even religious freedom to the point that the majority religions can impose their will on not only the government, but the minority people. You see that a lot right now in the non-discrimination settings, public accommodations where, right now it started with florists don't want to make the flowers for a gay wedding, bakers don't want to cook the cake, videographers don't want to take the pictures or videos, but that's just a small piece of where it's going. And now you're seeing it in the religious exemptions under Health and Human Services that say, and while we're here, we think that if people have a religious objection to treating people in the healthcare industry, they should be able to say, I'm not going to treat you. And there was recently guidance passed by the Department of Labor saying you can't force people who contract with the federal government to treat all their employees the same, even when they're performing federal jobs for the government with federal money. If they're a religious organization, they can treat you according to what their religion tells them to. So I do think that we are seeing a shift, but I don't think the pandemic is really affecting it. I think it's something that, if anything, it's probably delayed it a little because of the fact that the courts have been interrupted. The Supreme Court hasn't been able to have its full hearing schedule because they now are trying to learn how to use the phones for conference calls. While all of us are using Zoom, the Supreme Court's still trying to learn how to use the phones. That's what I think. I don't think the pandemic really is going to have a major role because I don't think the courts have bought into the setting aside of executive orders because of religion has been, so, other than the Sixth Circuit, which I mentioned in the case in Kansas, but those are rare cases.
We've got a couple of questions that are a little more general. Maybe Sarah could come back on at this point, and Nancy, and we'll see about who would like to answer these. The first one has to do with a political prediction that when the president changes from the one president to another after an election, frequently policies change. When Trump took office, his administration changed the government's position in some lawsuits. And if we have a change in administration next year, do you think that some of these lawsuits that you've been talking about will lose government support, might go away?
Well, okay, so first of all, the lawsuits I talked about at the beginning that are currently before the Supreme Court, those are already a done deal. I mean, they'll decide them this month. However, it's interesting you say that, because talking about the transgender discrimination case in employment, the Harris Funeral Home case. Originally, it was Harris Funeral Homes was the defendant, and the EEOC brought the case on behalf of Amy Stevens. And so in that particular case, the EEOC under the Obama administration was taking the position that Harris Funeral Homes can't discriminate against her. When it got to the Supreme Court, Trump administration changed its position and actually argued just the opposite. So the answer to your question is yes. When there's a change of administration, there are a lot of things that can change. If there's litigation, the Solicitor General's office at the Supreme Court can choose to take a different position on behalf of the government, although sometimes they get a lot of heat for why they changed their position. If there is regulations that have been enacted through one of the agencies, depending on whether they're recent, like from now till the end of the year, if there's a change this year, the incoming Congress can set them aside without having to go back to scratch and starting over. Otherwise, the agency would have to repeal them, and that's a very cumbersome process, and it requires the agency to have certainly a legitimate and usually a pretty good reason for why they're changing the regulation. The Trump administration has been doing some of that, although not very adeptly, because a lot of the people that were put in place had no experience on how to run an administration. But they have changed some regulations, and I think a favorable administration would not be hesitant to try to put some of the stuff back.
Yeah, and this is Sarah. I'm sorry, also my light just went dim on me. But yeah, absolutely. I think this is such an important point and a really smart question from our friends in Texas. Yeah, when the administration changes, whenever that may be, later this year or in 4 years from now, there is an opportunity to change policy, to rewrite regulations. But there's been so much that has happened under the Trump administration that there's going to be sort of some jockeying in DC. So one of the things that we're doing at AU, we don't get a lot involved in electoral politics because we're a 501c3, but we can plan for changes in administration. So right now, our public policy team is sort of sitting down and starting to write what's called a transition plan. We sort of write one in advance of each major election to think about, if there is a change in administration, what are our top priorities that is within the power of a new administration to change or update or claw back or rewrite? What are our priorities? That also requires us to have demand from you, from voters, from residents and citizens of this country. The next administration, whatever those changes they decide to make, if we move towards an administration that's more favorable to separation of religion and government, it's going to have a lot of asks from a lot of different communities. And so one of the jobs of chapters like you all there in Houston is to generate the support for those changes so that we can show a new administration that the public is demanding some of these changes. So we're going to be really excited to continue to partner with you all in Houston as we start to think about that transition plan and how we can show a new administration, if there is one, that there's demand all across the country for those changes.
I might also add, Texas is going to be an interesting state because there has been a growing divide between rural and urban areas in Texas. Not just that they haven't always been different because of the characteristic of being rural and urban generally, but ironically, the governor has beckoned for lots of people to move their businesses to Texas because of a favorable tax structure. And a lot of people in California listened and moved. And so what we're seeing is that there are a lot of areas of the state that really are about as blue as you ever would have thought they would be at this time. And so it's going to be interesting to see how that plays out in Texas, because I think you are going to see people who are going to put pressure at the state level, which right now at the state level, it's still a very red election profile. But I think you're going to see, when you look at the responses to the pandemic, when you look at Harris County, when you look at Dallas County, I mean, you're seeing some very, very progressive responses that are very, very much science based. And I'm not sure you're seeing that in other parts of the state. So you're going to be one of the more interesting states to watch, because I think you're in the midst of a rapidly changing dynamic.
Well, thank you very much, Ken. We really appreciate your bringing your knowledge and experience. This has been excellent. I'm going to begin to call the meeting to a close at this point. Thanks to everyone who participated. This has certainly been an experiment for us to be able to have a Zoom annual meeting. We need your support. Americans United in Washington, Americans United Houston chapter very much needs your support. If this has inspired you in some way, if this has scared you in any way, please join. Please support us financially in our efforts in the legislature, in supporting litigation, and all of the ways that we do our work. This is a time where church-state separation is under such heavy attack that we need to be able to defend it. So we certainly encourage you to support us in every way that you can. You see the screen. To join or donate, go to auhouston.org. We appreciate financial support in any amount. If you support us with $35 or more for a year, you become a member of AU and you can become a member of the Houston chapter. So we certainly hope that you will do that. So thank you all for being here, and we will tell you all good night.